You could call it a big moment for First Amendment rights. A New York City judge allowing a jury to continue deliberating former Alaska Governor Sarah Palin's libel case against the New York Times, despite announcing Monday that he has plans to dismiss the lawsuit. The judge says the one-time Republican VP nominee failed to prove malice when the Times published a 2017 editorial. Now, the article suggested her political action committee had encouraged violence by circulating a map of electoral districts that put Democrats under stylized crosshairs. The judge saying Monday he'll allow the jury to reach a verdict in the event that an appeals court reverses his decision. Julia Manchester from The Hill joining me now to discuss this. Julia, maybe we start with giving this a little more context. Why is the jury still deliberating?
Yeah, Adrienne, this was essentially done by the judge in this case, in the case that, the jury, in the case that an appeal is filed against this decision. That's something the judge very much expects. If the jury does rule in favor of the New York Times, the judge has said he will let that verdict stand. If it goes against the New York Times, then he will intervene with that decision he announced yesterday. But this is a very interesting case, I would say, given the political rhetoric we've seen recently, Adrienne, especially, in the wake of the January 6th attack on the Capitol. We know that this editorial published by the New York Times happened in 2017 after the shooting of Congressman Steve Scalise at a congressional baseball game practice. So definitely very relevant to what we're seeing right now in terms of the political rhetoric, but it seems like this is favoring the New York Times.
Well, and it's interesting that you bring up those very big, well-known cases now. It'll be interesting if this really has anything to do with how we look at these kinds of situations moving forward, maybe setting precedents. Why did the judge think Palin's case against the Times was lacking?
Well, he said it did not involve actual malice, and that the New York Times and that editor who published that editorial did not have actual malice against Sarah Palin, that it was a genuine mistake, and the Times very swiftly corrected that, issuing a correction after it was published. However, we've seen that Sarah Palin's lawyers have essentially said, look, there was no formal apology to Sarah Palin, but of course the New York Times and their supporters have argued that that correction, that walking back of that claim in that editorial does stand as an apology.
So really that correction was, again, it was like, oh, no harm, no foul. But in terms of an appeal, is this judge pretty certain that an appeal will happen because of the public knowledge of this case, because it is such a big deal?
That's what it seems like, and he is expecting an appeal to be filed in this case. But, I think we can definitely expect that. And in terms of defamation, we do know, and the judge said there's a very high standard for actual malice in defamation cases, but it'll be interesting to see what kind of precedent this sets going forward for defamation cases. If an appeal is successful, will that make it easier to sue for defamation cases? If an appeal isn't successful, if the judge's dismissing of this case stands, will it make it harder or keep the same standard for defamation cases? I think that's what a lot of legal experts will be watching going forward.
Absolutely. Thank you so much, Julia, as always. Thank you so much for watching. Make sure to click on the red subscribe button below so you can get more of NewsNation's fact-driven, unbiased coverage.